I still remember the first time I read the NRA's latest legal filing. It stopped me cold. The National Rifle Association's Institute for Legislative Action, NRA-ILA, has officially urged the U.S. Supreme Court to take up Jaman Rush v. United States, a direct challenge to the National Firearms Act, NFA. To most people, that might sound like just another legal fight. But to me, and to millions of gun owners across America, this case could redefine the Second Amendment as we know it. For nearly 91 years, the NFA, enacted in 1934, has imposed strict taxation, registration, and regulation on items like short-barreled rifles, SBRs, and suppressors, weapons that the government deemed dangerous or concealable. Yet today, those very same items are commonly owned by law-abiding Americans who simply want to exercise their constitutional rights. The Seventh Circuit Court of Appeals, however, decided that SBRs are not even protected by the Second Amendment, an interpretation that directly contradicts the Supreme Court's own rulings in District of Columbia v. Heller, 2008, and New York State Rifle and Pistol Association v. Bruin, 2022. When I read that, I knew this wasn't just another lawsuit, it was the legal equivalent of a powder keg. The NRA's filing doesn't just ask for relief, it challenges the very foundation of how Washington regulates firearms. It questions whether the federal government has the power to tax, track, and criminalize ownership of common firearms that are clearly in common use. In this video, I'll break down everything, from what this case is really about to how the Department of Justice has responded, and why this could be the most consequential 2A case since Heller and Bruin. Because if the Supreme Court takes up Jaman Rush v. United States, the era of unchecked federal gun control might finally be nearing an end. When I first read through the NRA-ILA's reply brief, I realized how much was truly at stake in Jaman Rush v. United States. This isn't just a question of paperwork or permits, it's a direct confrontation with the National Firearms Act of 1934, NFA itself, one of the oldest and most restrictive federal gun laws still on the books. The NRA's Institute for Legislative Action, ILA, backed by the renowned law firm Cooper & Kirk, LLP, represents Jaman Rush, a gun owner who's challenging the government's authority to demand registration and taxation for owning a short-barreled rifle, SBR. According to the NRA's brief, the NFA violates the plain text of the Second Amendment, which guarantees the right to keep and bear arms. Their position is simple. If a firearm is commonly owned by law-abiding citizens for lawful purposes, it's protected, period. They argue that short-barreled rifles meet that test. These are not exotic, military-only weapons. They're functionally no different from standard rifles except for having a shorter barrel, typically under 16 inches. There are now over 850,000 legally registered SBRs in the United States, a number that keeps growing every year. The NRA's argument is that when hundreds of thousands of citizens own them, they're by definition in common use. But the Department of Justice, the DOJ, sees it differently. The DOJ argues that the NFA doesn't ban SBRs, it merely regulates them through taxation and registration. According to their brief, that makes the law consistent with the country's historical tradition of regulating dangerous or concealable weapons. They also cite United States v. Miller, 1939, an old Supreme Court case that upheld restrictions on a short-barreled shotgun, claiming it wasn't a weapon in common civilian use at the time. Here's where the NRA fires back. They argue that the DOJ's reading of Miller is outdated and wrong. The 1939 court didn't say the government can ban short-barreled weapons. It simply said there was no evidence showing that type of firearm was in common use then. Times have changed. With modern ownership numbers proving the opposite, the NRA believes Miller no longer justifies restricting SBRs today. For me, the core question here isn't complicated. Does the federal government have the right to tax, track, and criminalize ownership of ordinary firearms used by ordinary people? If the answer is no, as the NRA contends,
then this case could become the first domino to fall in dismantling decades of unconstitutional overreach. As I dug deeper into the NRA's legal strategy, one thing became clear. They're not just fighting for Jaman Rush. They're fighting to restore how the Second Amendment was originally meant to function. In their reply brief, the NRA-ILA builds its case around two major Supreme Court precedents: District of Columbia v. Heller, 2008, and New York State Rifle and Pistol Association v. Bruin, 2022. Both of these landmark rulings reaffirmed that the Second Amendment protects all bearable arms that are commonly possessed by law-abiding citizens. The NRA's argument is that the Seventh Circuit Court of Appeals outright ignored that standard. When the lower court declared that short-barreled rifles aren't even covered by the Second Amendment, it effectively rewrote constitutional language. The NRA calls this a dangerously wrong turn, one that directly contradicts what the Supreme Court has already made clear. Their brief cites Heller's precise language. The Second Amendment's plain text extends prima facie to all instruments that constitute bearable arms. In plain English, that means if it's something a person can carry for lawful purposes, it's protected, period. But the NRA goes further. They highlight that Heller and Bruin don't require Americans to prove why they own a firearm, they simply affirm the right to own it. The Seventh Circuit Court's mistake, according to the NRA, was demanding proof that people use SBRs specifically for self-defense rather than simply acknowledging widespread lawful ownership. That's a fundamental misinterpretation. As the NRA points out, the right to keep and bear arms doesn't depend on how often a weapon is fired in defense, it depends on whether citizens possess it lawfully and commonly.
The Department of Justice, DOJ, meanwhile, argues that the NFA's restrictions fit within a historical tradition of regulating dangerous or concealable weapons, referencing 19th century taxes on Bowie knives, dirks, and pocket pistols. But here's the problem. Those examples came decades after 1791, when the Second Amendment was ratified, and most were localized measures from southern states seeking to disarm freedmen or restrict the poor. The NRA calls this historical cherry-picking, a distortion of Bruin's framework, which demands evidence of broad, founding-era analogs, not selective 19th century outliers. For me, this is where the NRA's position becomes especially compelling. They're not just relying on rhetoric, they're leaning on historical integrity. The Bruin decision explicitly warns against using post-founding regulations to justify modern infringements. The NRA's brief holds the DOJ to that same standard, arguing that the government can't invent a false history to justify modern infringements. If the court agrees, Rush v. United States could become the defining test of how faithfully America applies the Second Amendment's original meaning in the 21st century. The Department of Justice, DOJ, has been calling itself the most 2A-friendly administration in modern history, but reading through their arguments in Jaman Rush v. United States, it's hard to see that claim as anything more than a talking point. Their brief paints the National Firearms Act as a modest law that simply regulates firearms through taxation and registration, not as an infringement of constitutional rights. But when you dig into the legal foundation they're standing on, the cracks start to show quickly. The DOJ's first major argument is that the NFA doesn't prohibit ownership, it just requires registration. In their view, that's no different than registering your car or paying a tax on cigarettes. But this comparison falls apart immediately because no one's constitutional rights depend on owning a car or a pack of cigarettes. The Second Amendment isn't a suggestion, it's a fundamental right. The moment a government forces you to pay a tax or enter a registry just to exercise that right, it stops being freedom and starts being permission. The DOJ's second line of defense is procedural. They argue that Rush's case fails because it's a facial challenge, meaning he's arguing that the law is unconstitutional in every possible circumstance.
The DOJ claims that since the NFA can be applied constitutionally in some cases, like preventing felons from obtaining unregistered weapons, it can't be struck down entirely. But the NRA's brief hits this argument head-on, reminding the court that Heller 2008 was itself a facial challenge. If the DOJ's reasoning were correct, the Heller decision, which struck down Washington, D.C.'s handgun ban, could never have existed. Then there's the historical justification. The DOJ tries to anchor the NFA's legitimacy in United States v. Miller 1939, claiming the case already settled that SBRs aren't protected arms. But that's a hollow argument. The Miller court never ruled that short-barreled weapons were illegal. It ruled that no evidence was presented to show they were commonly owned for lawful use at that time. The NRA points out that this is no longer true. Today, hundreds of thousands of SBRs are legally owned, used in sport shooting, home defense, and collecting.
From where I stand, the DOJ's defense looks more like a bureaucratic shield than a constitutional one. It's designed to preserve power, not protect people. Their arguments may have worked 50 years ago, but under the Bruin standard, which demands real historical evidence for every gun restriction, the DOJ's case simply doesn't hold up. The more I study Rush versus United States, the clearer it becomes that this isn't just about one man's firearm, it's about redefining the limits of government power. If the U.S. Supreme Court agrees to hear this case, it could become the single most consequential Second Amendment ruling since Bruin, 2022, and Heller, 2008. Why? Because it directly confronts whether the federal government can continue regulating certain firearms under the National Firearms Act, NFA, using a model built in the 1930s, a model rooted in fear, not constitutional text. The NRA's brief argues that the Supreme Court's modern test from Bruin demands a clear historical analog from the founding era, circa 1791, to justify any gun regulation today. And that's where the government's defense falls apart. The NFA's taxation and registration scheme didn't exist or anything remotely like it when the Bill of Rights was ratified. It was created in 1934 in the aftermath of sensationalized media coverage surrounding gangsters like Bonnie and Clyde, John Dillinger, and the infamous St. Valentine's Day Massacre. Those events fueled public panic, and Congress responded with legislation that targeted fear, not fact. That same fear-based model still shapes U.S. gun law nearly a century later. If the Supreme Court takes up this case and sides with Rush, the implications will be massive. Striking down the NFA's SBR provisions could dismantle a cornerstone of federal gun regulation. It could call into question the constitutionality of restrictions on suppressors, short-barreled shotguns, and even the ATF's firearm classification system. The ripples would extend into the Gun Control Act of 1968 and beyond, forcing lower courts to reevaluate how they apply Bruin's historical test in every future case. But it's more than just a legal precedent. It's about restoring balance between freedom and federal power. For nearly a century, law-abiding citizens have been treated like potential criminals for owning items that are in essence ordinary firearms. If Rush versus United States succeeds, it could reestablish what the Second Amendment was always meant to guarantee, that the right of the people to keep and bear arms shall not be infringed, not by fear, not by bureaucracy, and not by outdated laws from a bygone era.
As I step back and look at everything we've covered, one thing is certain. Rush versus United States isn't just another Second Amendment lawsuit. It's a turning point. The NRA, through its Institute for Legislative Action, NRA-ILA, has taken aim directly at the National Firearms Act of 1934, NFA, calling it unconstitutional under modern Supreme Court precedent. The Department of Justice, DOJ, insists the NFA is a vital public safety tool, but the truth is, it's a relic of fear-driven politics from nearly a century ago. The laws born in 1934 were written for a world that no longer exists. For me, this case represents the clash between two visions of America. On one side, a government that believes freedom must be managed, tracked, and taxed, and on the other, citizens who believe that rights are not permissions granted by the state. The Second Amendment doesn't say the right to bear arms exists unless you pay a tax. It says that right shall not be infringed. If the U.S. Supreme Court agrees to hear Rush versus United States, it could redefine how the Second Amendment is applied in every court across the nation. A ruling in favor of Rush would not only challenge the NFA's registration system, but could also ripple through other laws, from the Gun Control Act of 1968 to parts of the ATF's classification system. This could mark the first real rollback of federal gun control since Heller 2008 and Bruen 2022. So where does that leave us? It leaves us on the edge of history. As someone who's watched our rights erode over time, I can tell you, this case isn't just about a short-barreled rifle. It's about restoring the meaning of the Second Amendment itself. And if the court takes it, the future of gun rights in America might never look the same again.